covenants to protect your trade secrets, customer relationships, and workforce. As you'll learn over the next hour or so, there's been a lot of changes in restrictive covenant law over the last 2 years. There's more changes on its way. So it's good to have an understanding of what it is with respect to not only restrictive covenant changes, but trade secret changes and how they will impact not only your agreements, but your ability to hire competitors' employees, as well as enforce restrictive covenants and prevent trade secrets of your company going out the door into a competitor. So, like I said, my name is Scott Humphrey. I am the partner and chair of the Trade Secrets Restrictive Covenant and Unfair Competition Practice Group here at Benesch. I've been practicing in this space for over 22 years. It's hard to believe it's been that long, but it has. My practice is usually about 60% litigation, both enforcing restrictive covenants as well as defending against restrictive covenant claims, as well as 40% on the consulting side, where we review restrictive covenants and advise companies on potential hiring risks because of them. We perform trade secrets audits in order to identify and protect trade secrets. And we develop processes and procedures for companies to follow and enact when they have either a trade secret risk or a potential competitive hire occurring, and they need to do forensics, cease and desist letters, and the like. So what we'll cover today and why I'm here is we'll first go over what they are, and just as importantly, what they are not with respect to restrictive covenants. We'll dive into some state laws, especially some that have changed over the last 18 months. We'll talk about trade secrets, and then we'll jump into best practices and practical considerations, as well as enforcement options. And I'm happy to field any questions that you may have. Also happy to field them after this call. You'll have my contact information at the end of this presentation as well. So let's go ahead and get started. I think any starting point has to be, what are restrictive covenants? And really, to break them down is three things. They limit the moment of a departing employee through and preventing the individual from working for a competitor or in a specific territory for a specific period of time, from soliciting customers for a specific period of time, and from soliciting employees from for a specific period of time. Those are really the three restrictive covenants that you typically see. They're governed by state law, and what that means is a restrictive covenant that's enforceable in New York or Illinois may not be enforceable in Ohio or Wisconsin, and definitely isn't going to be enforceable in Oklahoma or California. Also, the courts and the states invest a lot of power in the trial judge. And therefore, it's not uncommon to see a trial judge in one state. I'm in Chicago, for example, so a judge in Cook County rule that an agreement's restrictions are enforceable, and another judge in the same building determined that similar restrictions or maybe even identical restrictions are not enforceable. So that's why when you go into litigation, it's important to know what state you're in, and as well as to what the typical rulings are coming out from those local trial judges. As I mentioned before, here's the three types: non-competition, non-solicitation of customers, and non-solicitation of employees. Where you need to be careful, and this has been one of those changes over the 18 months, is sort of an offshoot of the non-solicitation of employees, is a no hire provision. Courts have started striking those down, and the FTC and the SEC have also started investigating no poach agreements between companies. And the SEC in particular has been claiming that those are antitrust violations. They have actually been taking companies to court, as well as senior executives who enter into no poach agreements with their competitors. So we have to be careful with that, and we'll talk about that in a little greater detail a little later on. Common limitations, we refer to this as TAG: time, activity, and geography. One of the questions that we always get asked a lot is, how far out can we go with a restriction? And because they're state by state, you have to realize that certain states do lesser restrictions, certain states do longer restrictions. The maximum non-solicit restriction that's out there is probably Florida. Florida has a statute which says anything 2 years or less is presumptively reasonable. take that, to California, that has a blanket prohibition on non-competes, as well as say Missouri or Kansas, where more likely than not, the restriction is only going to be enforced if it's 6 months or less. So you need to understand what state you're in with respect to that time. We generally say as a rule, don't go beyond 1 year with respect to your employees. Now, with respect to a sale of a business, that's a totally separate animal. You can go out 3, 4, maybe in some situations 5. But with respect to today's day and the environment that you're seeing throughout the country, we usually caution companies in writing their restrictions to not go out more than 1 year. Activity, it can be, don't work in this area, as I mentioned before, don't solicit these customers, do not engage in competitive activities. With respect to customers, one of the things you're going to want to make sure that your restrictions cover is that it states that it only covers the customer that the individual dealt with or possessed confidential information about. If you're a large company and you have customers across the country, you're not going to be able to enforce a blanket prohibition on all of your customers, especially against regional employees. So by example, if you have somebody whose sales territory is the Midwest, you're going to want to say you will not solicit customers within the Midwest, as opposed to you will not solicit any of the company's customers. Same thing with geography or a customer restriction. You want to tailor that geography to the area that that individual covered or had confidential information about. So again, if they're a regional vice president of the Northeast, that's their territory, and you can write it in so that the restriction says you will not compete in the territory that you had responsibility for our confidential information about our interactions with customers with while working for ABC company. So what I said is that there's been a lot of changes over the last 18 months. It's been pretty noticeable. And it's not been just solely with respect to the length of restrictions, but it's now been with respect to compensation thresholds and notice provisions and getting additional consideration for signing a non-compete other than continued employment. So we'll talk about those in a minute. But first, clients will do is that they'll write for their California employees, you will not use our confidential information to compete. You will not use our confidential information to solicit. That is allowed in California, but just keep in mind that that's a much more restriction than just a blanket prohibition. A blanket non-solicitation, because whereas in other states, you just have to show that they're soliciting. In California, you would have to first show that they're using your confidential information. Louisiana, for those of you who are not familiar with it, they have parishes. Most of us would refer to those as counties. But the way Louisiana has written its non-compete statute is if you have people in Louisiana that you want subject to a restrictive covenant, you need to identify the specific parishes. And there's 63 parishes in Louisiana. So, feel free to contact me. I can dive into more detail about Louisiana. We could spend an hour just talking about Louisiana on its own. But that's what you need to know with respect to Louisiana, is that if you have individuals in Louisiana, you need to have a non-compete that specifically identifies the parishes. North Dakota is like California, blanket prohibition. Oklahoma has a similar prohibition, but it's only with respect to a non-competition agreement. So in other words, you cannot in Oklahoma enforce an agreement that says that you will not compete with us, but you can still enforce in Oklahoma an agreement that says you will not solicit our customers or employees. So where are the trends I was talking about earlier? Low-wage employees is the big one, and that's all across the board, as to what that means. Some say it's below the poverty line, some say it's below $20 an hour, but generally speaking, and this goes to when you're tailoring your agreements, now you really want to take an extra effort to think twice about, oh, maybe I'll just have everybody in the corporation sign this. No, the better practice now based upon these changes in state laws is to say, okay, who is it that we're really concerned about leaving? And if so, let's have those people sell it. Or if they left, who could do the most damage to us? Maybe, a lower level salesperson who only has 2 clients and they're just on the client chain, as opposed to the person who's been with you 10 years, has $100 million in sales. Those are two different, individuals in your organization. Maybe you no longer need a restrictive covenant agreement for both of them. Compensation thresholds, and I'll show you those in a minute. That's in 10 states right now. We expect it to go up to maybe 12 next year. And that is saying, with respect to certain agreements, you have to be making a certain wage or receive certain compensation in order for them to be enforceable. Notice provisions. This is a big one too. You're seeing this. In fact, the most recent statute, Colorado, that just came out in August 10th of this year, is that states are now requiring you to give notice before the person joins with your company that they will have to sign a restrictive covenant. Some of that language is now also saying that you have to tell them that they have the right to consult with an attorney. We'll talk about best practices for that a little while from now. With respect to the law, as you see here, 70 bills were introduced last year that contain non-compete restrictive covenant items. There's already been an uptick to 98 this year. Most have gone away. Colorado and Washington, D.C. haven't, and we'll talk about those in a minute. But there's still 36 that are active. And when people ask, well, Scott, what's the most active? Are the ones that we're watching them closest? It's by far New York and New Jersey. New York and New Jersey have multiple bills pending right now with respect to restrictive covenants, and they range the gamut from compensation thresholds to actual blanket prohibitions on restrictive covenant agreements. It's unclear how that'll shake out, but we'll continue to monitor it. And we send out a quarterly update each quarter where we list what's going on. So please, if you're interested, let me know, and I'm happy to add you to our quarterly update list. But New York and New Jersey are the ones that are giving us the most heartburn right now because of those bills. So the biggest one of last year that went into effect in January 1st of this year is my home state of Illinois. What it says, and this covers pretty much all the new trends that we talked about, is with respect to a non-compete, your employees have to be making over $75,000 or they're not enforceable. For a non-solicit, they have to be making over $45,000. And so this goes back to that best practices that I mentioned a minute ago about, maybe it's time to rethink that we're just going to have everybody in the corporation sign it, because these statutes are pretty draconian with respect to sanctions. For example, in Illinois, the employee can recover their attorney's fees. In fact, it's mandatory if you sue them under what the Illinois courts deem to be an enforceable provision or an unenforceable agreement. Illinois also has the 14-day notice provision, and that's the one where I said before is before they even join you, you have to show that they had 14 days to consider their agreement, knowing that it has a restrictive covenant in it, and that you also told them that they have the right to consult with counsel. So again, going to best practices, there's more and more states that are adopting this notice period. It probably doesn't hurt, for example, just put in the offer letter. Congratulations, we can't wait for you to hire. Your first day of employment will be X. As you'll see in this offer letter, you will be required to sign an employment agreement that contains the following restrictive covenants. That's how we have been handling this. Colorado is here for two reasons. One, as I mentioned, they're the most recent, but also they're the ones that have really gone the furthest with respect to extremes. And what they did on theirs was they actually made it a criminal misdemeanor if you attempt to enforce what Colorado deems to be an unenforceable restrictive covenant. That misdemeanor is punished by a $750 fine or 120 days imprisonment or both. Now, it seems unlikely that a local prosecutor or the Colorado Attorney General would have any interest in going after a company who went and tried to enforce a restrictive covenant agreement. But nevertheless, that statute's on the books, and we got to be aware of it. Similar to Illinois, you see these non-compete over 100,000, non-solicit over 60,000. I don't know why, candidly, Colorado did 101,000 as opposed to 100, but they did. Also, like Illinois, You need to provide notice to the employee of the restrictive covenant. And the new wrinkle that nobody has done before, that Colorado is the first to, and this is in one of the New Jersey bills, by the way, is that the employee has to sign the notice acknowledging that they were made aware of the potential to sign a restrictive covenant. So if you have employees in Colorado, you have to not only give them the offer letter, tell them that there's a restrictive covenant, but you also have to have a signature line on the offer letter asking them to return it to you. And that signature line acknowledges that they are aware that they will be subject to a restrictive covenant when they join your company. So Oregon is, we listed here because it's an example of what what has gone on over the last couple of years. Oregon's kind of a microcosm of what we've seen. And that is, they started out revising their non-competes. In May, they shortened the non-compete period down to 12 months. Before that, as of last year, I believe it was in February of last year, they said, 18 months is good. And 2 years ago in their statute, they said 24 months with respect to a restrictive period are good. Not anymore. Now it's got to be 12 months. And again, also with a compensation threshold only for non-competes, it has to be over 100,000. That individual, in other words, has to make over 100,000 in order to enforce a non-compete. They don't have to make over 100,000 to enforce the non-solicit of customers or the non-solicit of employees. Also, and this is important, is all restrictive covenants pretty much have, or if they don't, they should have language in there that says something along the lines of, to the extent a court finds that any provision of this agreement is unenforceable, the court has the authority to rewrite or modify the agreement in order to come into compliance with the law. Well, Oregon took that provision and made it void. What Oregon is basically saying is, companies, you got one shot. You don't have that backup. So it's either going to be enforced or it's going to be struck. There is no middle ground. Whereas in, say, Illinois, Colorado, New York, New Jersey, Florida, Ohio, pretty much all the other states, there's blue penciling where the courts are free to modify the agreement if they have to. This Oregon legislature, state legislature, took that quiver out of the courts, took that arrow out of the court's quiver this year. One of the things that you should know about is Congress has really stepped up legislation. Now, not actual enactment, but legislation with respect to restrictive covenants. And this stems back to when President Biden was Vice President Biden. Back when he was Vice President to President Barack Obama, Biden would talk about how he believed that restrictive covenants were restraint on trade, unfair competition, and that he thought they should be abolished. He actually campaigned, and that was one of his campaign platforms, was that he was going to work with Congress to abolish restrictive covenants. And obviously that wasn't a big issue in the race. Not many people vote on that issue, but nevertheless, that was one of his platforms. So it wasn't a surprise that shortly after he took office, he tried to reach out to Congress and tried to get some traction with respect to either knocking out completely or modifying restrictive covenants and making it a federal issue instead of a state issue. Congress has no appetite for this. And basically it was like, okay, well, sure, Mr. President, we'll put some legislation out there, but it's going to be stalled in committee. So this Workforce Mobility Act, the Freedom to Compete Act, yes, they're out there on the congressional docket. You can read about them if you want to go look at potential legislation, but they haven't done anything and they really haven't gone anywhere. And President Biden, I think, realizing that he wasn't going to get anything through Congress, then decided to go out on his own. And what he did was he told the FTC, the Federal Trade Commission, to, issue a memorandum letting people know that you're going to start considering whether you need to curtail the, quote, unfair use of non-competes. And so the FTC issued a order, or not really an order, I would say a memorandum saying that they were going to look into this and they're going to decide whether or not they can issue rules with respect to what is and what is not an enforceable restrictive covenant. And that covers all three: non-compete, customer non-solicit, and employee non-solicit. I was one of 60 trade secret non-compete lawyers who sent a letter to the FTC and to the White House outlining why we thought this was a bad idea and why this is better left to the states. The White House actually responded back saying that they would, they appreciate us and they would like to meet with us, but they've never scheduled a time for us to actually come in and meet with them. But what they did do was that they then asked the DOJ to step in and help the FTC. And so there was a workshop in December, another one in May, where they heard from academics, they heard from corporations, they heard from individuals, and they being the FTC and DOJ, where they said, okay, tell us what about it. And initially it was pretty one-sided. It was a lot of academics and economists saying, hey, listen, these are bad for the country, these are bad for individuals, there are illegal restraints on trade, et cetera, et cetera. The Chamber of Commerce finally started weighing in candidly at the prodding of a lot of us, and started showing like, whoa, wait a minute, these studies are flawed, they're not accurate. Restrictive covenants do provide a vital role, with respect to company goodwill, legitimate business interest, customer relationships, stable workforce, and so we're going to wait and we're going to continue to work with, to the extent that we can, the FTC to see where this goes. But I suspect you probably get emails from attorneys that or maybe you don't know, saying, oh my God, this is what's going on at the federal level. And they're totally right about that. But I would caution you on doing anything with respect to the DOJ or the FTC's investigation or examination is a better word of restrictive covenants. The reason why is this will be a brawl if the FTC actually decides to do anything, because first off, there's no saying what the rule would be. And it's going to be an executive order. So if it's an executive order and President Biden loses the White House in 2024, the Republican president can simply resolve the executive order. And so everything the FTC did, DOJ did regarding restrictive covenants is done. It's gone. Second, odds are that this would, if there is some executive order, Congress probably would step in here. And that's where I think you'd see a lot of hearings, a lot of issues with respect to things being raised before Congress. And so I don't think the executive order or the FTC guidelines would carry the day. And third, there's going to be a lot of litigation because this is a state right, and there's a real question of whether the FTC would even have the charge, or in simpler terms, jurisdiction over issuing rulings and President Biden issuing an executive order on an issue that for over 200 years now has been an issue with respect to the states and not the federal government. So that's a long way of saying we're watching it. There's nothing to do now, but stay tuned and we'll keep you abreast of what's going on. The last one, and this just happened a couple days ago, staying in Washington, is they have now passed a restrictive covenant statute, the DC legislature has. And what that means is that for non-competes, if anybody works in the district, they have to be earning over $150,000. If they are making less than $150,000 and the majority of their services are being provided in the district, then the non-compete is not enforceable. A non-solicit still is. What's interesting about this bill is that DC and federal government workers are exempted. So if you're working for the federal government or for DC local government, you can be subject to a non-compete if you're making less than $150,000, which is somewhat ironic considering that President Biden has issued an executive order asking the FTC to come up with guidelines to ban non-competes. The other little interesting tidbit here with respect to the ban on non-competes is there's also a carve out for casual babysitters. So if you're a casual babysitter in DC, say you're somebody who is a babysitter for a congressman, you're a nanny, you can be subject to a non-compete. it's simply mind-blowing. But we always point that out just, to let people know that, a lot of times with these statutes, you can't necessarily go back and come up with a rational analysis, but nevertheless, you're still left knowing that, okay, this is what the law is, this is what I need to do. For those of you who have folks in DC, you need to put out a notice in order to become compliant with the DC rule within the next 90 days. So before the end of the year, informing those individuals who make over 150,000 that they are subject to a non-compete. With respect to anybody you're hiring, though, go working into the district, you need to notify them within 7 days of the hire. Again, going back to that notice provision. So as I mentioned before, these notice provisions are growing. Here are the states that have them right now, and you'll see they're all over the board, from New Hampshire's prior to acceptance of the offer to Illinois' 14 days, and Oregon's 2 weeks. The other thing I would notice, I apologize, I should have mentioned this before, is Oregon also requires you to provide a copy of your agreement to the departing employee within 30 days of them leaving you. And with respect to compensation thresholds, as I mentioned before, they're all over the board. New Hampshire, 1450, Illinois splits it, Maine, 54,000, Rhode Island, 250% above the poverty level, which would mean for family of four, anyone making over $40,000. And so I'm not going to spend time going over each one of these states, but this slide points out the importance of understanding why now, unlike maybe 2 or 3 years ago, it's very difficult to have a one-size-fits-all agreement. Instead, what most companies are doing now who have a national employee base is that they are having multiple agreements, or they have one agreement with an exhibit that allows for certain exceptions. So for example, if you have a company-wide agreement, you would have Exhibit A that would say, with respect to Illinois, the non-compete in Section 4 only applies to those individuals who are making over $75,000 on an annual basis. So what are trade secrets? And the reason why we talk about trade secrets is in my line of work, trade secrets and restrictive covenants go hand in hand. And more specifically, what I mean by that is usually when somebody's going to compete and violate their non-compete, they usually also take something, most often a customer list, confidential pricing information, a marketing strategy. For those of you, and maybe high frequency, for those of you who have, source code, you use algorithms or something at your work, it's also not uncommon for them, to try to take, download source code, download, processing schemes, schematics, things like that. So it's important to know what trade secrets are and how there's an interplay between trade secrets and restrictive covenants. This is the long definition of the Trade Secrets Act of 2016. I encourage you to print this out and read this if you're having trouble sleeping at night, because it will put you to sleep. The better definition and the simpler definition is a trade secret is anything that is not known to the public and that gives your company an economic value, either current or in the future, as a result of you keeping it a secret and maintaining reasonable efforts to maintain its secrecy. The most common examples are the formula for Coke and the formula for Pepsi. Those are trade secrets, have been for over 100 years, and will continue to be so long as Coke and Pepsi do not publish the secret formulas. This goes into what we see a lot in restrictive covenant agreements. I shouldn't say a lot, but what we see often in restrictive covenant agreements is a confidential information section that says, with respect to our confidential trade secret information, you can't use it for 2 years, for example. The better practice, candidly, is to say that you will not use that confidential information for as long as that information remains confidential. For the individuals at Coke who know parts of the recipe, or maybe I believe there's only 3 people at Coke who actually know the full recipe, they're sworn and their agreements keep them from disclosing that information for as long as it remains confidential. So 2 years after that person leaves, they can't disclose the formula for Coke, even if they wanted to. But if they had an agreement that said they could, they could. So that's why, again, going to best practices with respect to confidential information, state it for as long as the information remains confidential. Here's a laundry list of examples of trade secrets. What I talk about here is just to let you know they can be anything. Again, they can be customer lists, they can be manufacturing processes, they can be pricing information, they can be compensation information, they can be bonus structures. Trade secrets can be anything that gives your company an advantage as a result of being a secret and not getting out in the public. And why does this matter? Well, if you go to KPMG, they put out a report earlier this year that said that publicly traded companies own an estimated $5 trillion worth of trade secrets. Okay, that's just public. And when I spoke to KPMG about this, I said, well, what about private? And they said, obviously, we can't get that type of data for a private corporation. But we think if you add private companies into this, it's probably around 8 to 10 trillion worth of trade secrets. They also estimated that the economic loss from trade secret theft is between 1 to 3% of US GDP, which means that's a $2 to $6 billion annual loss as a result of people stealing trade secrets. It comes as no surprise then that now this is on the CEOs and the board's radar. Obviously, because this is a significant economic, not to mention emotional, not to mention environmental, not to mention culture hit to lose these type of trade secrets or to be hit by that lawsuit from a competitor. And so that's why we're seeing, not only CEOs and boards take a more close look at this, and not just with respect to when it leaves, but preventing it from happening, but so too is the federal government. And here's one of the things I think is the most striking statement, especially with everything that went on during the Great Recession, which I think is more properly labeled the Great Relocation, is 68% of employees admitted to taking information when they left their former employer. And that's 68% of people admitting it. So you wonder what the real number is of the people that took it but just didn't want to admit it. But again, because of those things, that's why it's important to have protections in place so that you can identify when your trade secrets are at risk for getting out before they actually get out. And given those numbers, it should come as no surprise that there's been some rather large jury verdict awards this year. One jury awarded $240 million against a former employer and competitor who misappropriated trade secrets. Another jury awarded $854 million. These are staggering awards, and obviously they are very large. But keep in mind that what that also means is that's what the company lost as a result of the trade secrets getting out. And I think if you talk to most folks, they would say, I'd rather spend a lot less than $240 million and keep my trade secrets than spend a couple $1 million in 5 years in litigation to recover 240. The other thing, as I mentioned, is criminal activity, given the economic loss has arisen. You see this largely in the federal space from the U.S. attorney's offices. You do not see that as much in the local state's attorney, district attorney, or state attorney generals. I think they just don't have the resources for it. But in this year alone, you've seen sentences for stealing trade secrets range from anywhere from 1 year to 97 months. And what's important in this slide, and why we talk about the importance of a trade secret audit, is you'll see that it's everybody stealing trade secrets, from IT to sales to senior executives to competitors, taking it. So you have to be aware of where your trade secrets are at, who they are exposed to, who uses them, who may have access to them but doesn't need to use them, and what is your plan for if they get out or somebody tries to get them out. So the bad guys, you've probably heard plenty of this. China, Russia, South Korea are the biggest hackers and the biggest problems. China, of those three, China is the biggest issue. They have no thought or remorse for stealing trade secrets. That's just fact. The majority of the criminal prosecutions over the last 3 years with respect to trade secrets largely involved either Chinese nationalists or someone affiliated with China trying to steal U.S. trade secrets to take them back to China. But even said that, still 90% of the trade secret theft is done by somebody the company knows. A disgruntled employee, a business partner, or a competitor, usually through former employees, which isn't surprising when you remember that 68% of departing employees admit to taking stuff when they leave. How do they do it? You're not going to be surprised here. It's a lot easier in today's digital world, and it's an awful lot easier now because of COVID and remote working. downloads, screenshots, copying, emails, cloud, flash drives, all of that is the ways of 2021, 2022, and will be the ways for 2023 and 2024. So it's important to have mechanisms and processes in place that can identify when somebody's doing something nefarious or something they shouldn't be doing with your trade secrets. So let's talk about best practices. We talked on a lot of this before, but when you're drafting your agreements, here are a couple of considerations. I highlighted these already. Identifying the key employees is important, especially in today's day and age where courts are catching and starting to cast a bit of a jaundiced eye on just blanket agreements that cover every single employee. So you need to say, okay, who are the people that we really need to cover? Who are the people that have access to our confidential information? Who are the individuals that if they walked out tomorrow could really hurt us? Who are the individuals that have our strongest customer relationships? And then where are they located? Are they located in California? Or are they located in Illinois or Florida? The restrictions you need. It is obviously much easier these days to enforce a customer or employee non-solicit than a full blanket non-compete. So what we always talk to people is, hey, do you need the non-compete or do you think you'll get by with just a customer non-solicit? Also, multiple or tiered agreements. Maybe you have a 6-month non-compete for a salesperson, but a 1-year non-compete for a senior executive. Always remember to tie the restrictions to confidential information. The reason why we say that is because a lot of these statutes now are saying that they're only good to the extent they protect legitimate business interests. Confidential information is one of them. So put that up in the beginning of your agreements that in exchange for employment, bonuses, opportunities, and access to our confidential information, you're agreeing, employee, to the following. Again, always include confidential information. That's important. That doesn't have to have an end date. You can say, and I recommend that you do write that, the information you cannot use as long as it remains confidential. Attorney's fees is usually a good thing. Just be aware that some states like Florida, for example, as well as Arizona, have provisions in their statutes that say if there's attorney's fees provision in the contract, both sides can recover their attorney's fees. Form selection clauses. The thing to know about that is some states, Massachusetts, Illinois, New Jersey is thinking about, Oregon has one, Washington has one. They basically said that if you are looking to enforce a restrictive covenant against a citizen of their state, you have to file suit in their state. Those statutes are being challenged, but as of right now, they are what's on the books, and so you just have to be aware of that. So, for example, if you say, hey, listen, any dispute, any restrictive covenant dispute has to be brought in the state or federal courts of Delaware, and it's against a California employee. Don't be surprised if you see the California employee file a declaratory action in California seeking to throw out your agreement because California statute says they have to be sued in California, and California law applies, and therefore the restrictions are unenforceable. Onboarding employees. First things, and this is probably the biggest one, is you need to obtain all prior agreements. And this can sometimes be a delicate discussion, but it's a discussion that you have to have with the new employee. And it doesn't have to be confrontational. It can simply be, listen, we need to understand everything that could potentially impact your employment with us. Therefore, we need, any agreements that you have from your company. If you have hired from that person's employer before, and the first person had an agreement, the second person had an agreement, the third person says they don't have an agreement, you should be skeptical. And sometimes what we've done in those situations is said, okay, we need to, we're going to put into your employment agreement that you don't have any restrictions. And sometimes that's when the agreement shows up. And that's when you got to judge not only the credibility of the person, but also the enforceability of the restrictions and the impact that it may have on your ability to hire this person, or the role that the person could be able to use or operate in at your company for a period of time. The Employment agreements, like I said before, make sure you give them out ahead of time now. Like with Colorado, make sure that they sign and send it back to you, a notice acknowledging that they're aware of it. There is, and we do this on a flat fee basis. We do review restrictive covenant agreements with our clients. It's typically in the $500 range, where we walk through the client. All right, this person you're hiring has restrictive covenant. Here are the risks, and then we say, okay, here's the risk, and it's up to the business folks to say, okay, yes, we want this person and we accept the potential risk, or no, we don't think this person's a good fit and the risk is too great. But it doesn't hurt to get an outside counsel's opinion on restrictive covenants, especially when you're hiring from a competitor, because not only can they help in evaluating the restrictive covenants, but they can also help walk the individual through their leaving and departing from their former organization, so that you guys don't get hit with a lawsuit that names both the company and your new employee and alleges not only restrictive covenant violations, but also the theft of trade secrets. Now this happens. And it happens when sometimes it's intentional, sometimes it's not, where a new hire brings confidential information to your company. The first thing you need to do is you need to track it down. You need to follow the spider web, and you need to get it all back. The reason why is because if their former employer comes after the employee, they're also going to come after you, because now they know that you're in possession of their confidential information. And if you didn't try to collect it, courts can use and say, all right, well, that's not only misappropriation, but it's also an authorized use that's willful and wanton, and you can be subject to punitive damages and attorney's fees. So that's why when this is brought to your attention, you need to chase everything down, follow the spider web, and temporarily preserve the information through in-house counsel or a third-party forensics firm. You want it completely off your systems. You want, though, then to store it somewhere where it's preserved. So if the competitor comes after you, you can say, no, listen, this is all we had. It's been scrubbed from our system, and then you can destroy it. What we usually say is, hold it for about 6 months. If after 6 months there doesn't seem to be any issues, and then you can destroy it. But you definitely want to collect, isolate, and preserve it. Also, if it makes sense to do so, you need to document your chain and your process through legal. So that way, if anybody says, well, what did you do or what you didn't do, also, you need to at least consider. Sometimes it makes sense, sometimes it doesn't. What type of remedial action outside of collecting, isolating, removing, and preserving you want to do. Sometimes, these actions justify termination. Others, it wasn't the smartest move in the world, but the person shows a lot of potential, hasn't done anything else bad. And so, maybe it's better to teach this as a learning lesson. But what I'd also say is also remember the future impact of this, and that's on twofold. One, if you don't take remedial actions and then somebody comes in later on, a year or two, does the exact same thing, and you want to fire them, they're going to come back and say, well, wait a minute, Sue did all this stuff and you didn't go after her. Why are you going after me? Similar, if somebody then goes to that competitor, takes your confidential information with them, you want to show that you've always had clean hands, you've always operated in the right manner, and therefore, this competitor should expect to comply in the same ways that you will and you do in situations where confidential information has been brought to the company. So now offboarding employees. One, have a formalized process. A lot of offboarding is, oh, well, let's go have Joe talk to him, or hey, just have us in an email telling us when their last day is. If you have restrictive covenants and you have trade secrets, you're going to want to make sure that the person is going to honor them and is not walking out the door with any of your confidential information. And that's important not only from a business perspective, but also from a legal perspective, because if you go into court and you say, listen, they stole my stuff, I want it back. The court's going to say, well, what'd you do to try to get it back? What'd you do to try to prevent it from getting out? So it's good to have that process. And, that could be a separate topic for a different day, but generally it's, all right, here's a checklist so that HR legal can go through. Right of the obligations. I've given them the agreement. I've confirmed that they don't have confidential information. It's usually a good opportunity to give them a copy of their agreement, so therefore there's no confusion over what they do and do not owe the company after they leave. Also, have that checklist, have a signature line. So it says, Joe Smith, head of HR, met with Sue Jones on October 1st, and she confirmed the following information. Also have an escalation process. And a lot of this, we do this sort of, I'm a Six Sigma green belt. And so what we do a lot is we do process mapping where we say, okay, employee gives notice, step 1, HR gets involved, everything clean, go to step 2, exit interview. Maybe though HR gets involved, learns of red flag, go to step 2A. That's where we go and we look at their forensics, we go through forensics and look at their computer, look at the network to see where they've been in the last 30 to 60 days. Have they been downloading stuff they shouldn't be? Have they been sending stuff to a Gmail account? Have they been accessing areas of the company server that they didn't exercise or enter into in the 10 years that they were there? That is a process that you want to think about ahead of time, because all companies will eventually face these issues. It's not a matter of if, it's a matter of when. It is better to have your escalation plan in place and ready to go than trying to go at it on the fly. With respect to outside counsel, we're here to help. A lot of times we can help navigate the forensics. We can also issue cease and desist letters, and where necessary, we can take legal action to either prevent the individual from working or the return of your confidential information. And that goes into our legal options. And you typically have, the criminal and the civil side. For those of you who are unfamiliar with the legal system, that's basically the two systems. You have criminal, U.S. attorneys, prosecutors, defense attorneys, and then you have civil, which is your standard breach of contract. It also includes, personal injury, chancery, things like that. With respect to criminal referrals, I have worked with the FBI in the past, but it's usually pretty rare. Most of the time, the FBI and the U.S. attorneys only want to get involved if there's a foreign actor involved. For example, you have someone who you believe is looking to take those trade secrets out of the country to China, to Russia, to North Korea, what have you. And like I said before, the local prosecutors as well as state attorney generals, they just don't seem to have the bandwidth to handle this. They have enough on their plates. So most of your remedies are going to come through the civil side. And there's two statutes that you should be aware of with respect to trade secrets: the Defend Federal Trade Secrets Act and the Uniform Trade Secrets Act. Defend is federal, covers everywhere, gets you into federal court. Uniform Trade Secrets Act has been adopted in 49 of the 50 states. The one state that it isn't is New York, but New York's case law follows the UTSA. And that allows you to get injunctions, monetary damages, attorney's fees, and injunctive relief for anybody who steals your trade secrets. You also have your standard breach of contract, as well as in certain states, breach of fiduciary duty for any breach of restrictive covenant or misappropriation of trade secrets. With respect to those damages, lost profits, harm to goodwill, reasonable royalties. Most states, either in contract or statute, do allow for the recovery of attorney's fees as well as an injunctive relief. So what that means is, let's say you have somebody who has a 1-year non-compete, steals confidential information, goes to a competitor. You can get an injunction under both the Trade Secret Acts as well as your contract, as well as a breach of fiduciary duty that says, A, you're enjoined from working for that competitor, B, you're enjoined from using our confidential information, C, you are enjoined you are required in order to return all confidential information to us. And D, we have a finding that you intentionally took these trade secrets and therefore we're entitled to attorney's fees. All that in addition to the, hey, these trade secrets gave us $3 million a year in revenue. That's since been reduced to $1 million, so our damages are $2 million. That's all of the statutes and contracts and actions that you can have with respect to the violation of a restrictive covenant or the theft of a trade secret. As I mentioned here, injunctive relief, I just covered this. It can be everything from employee working for a competitor, soliciting customers or employees, accessing your trade secrets. What's important here is with respect to that injunction, you can have it apply to anyone that, quote, has notice. And so you can have an injunction in place with respect to an individual. You can then provide notice of the injunction to that individual's new employer, and they have to understand it and they have to comply by it. Also, what I always recommend in these situations is that not only do you have a motion for a temporary restraining order, preliminary injunction along with your complaint, but you also ask for expedited discovery, which the courts will routinely grant, which will allow you to inspect an individual's forensic devices such as their phone, their laptop, their flash drives, their home computer. That's an important tool here because when you're in litigation, it's not enough just to get the injunction. You also want to get that expedited discovery that allows for a forensic review because it's important to learn not only what did they take, but where has it gone? And that forensic review allows you to figure out that second part, where has it gone? So one of the things, and I know we're getting close to time here, and so I don't want to keep you too long, but this is what you need to decide on injunctive relief. Goals, legal and non-legal. Sometimes there's a strong legal reason to go after the injunction, but there might be an even stronger business reason not to. You just have to consider A, how does this impact the current situation, and B, how could this impact us in future decisions? Also, with respect to internal resources, and this is important, is especially now that courts are getting back to normal, we're having more in-person hearings. I actually had a TRO hearing in Delaware last week that was live. It's one thing to say, yes, we are there, we're committed, we're going. It's another thing to say, yes, we will have our two business folks on a plane in Charlotte, North Carolina on Tuesday so that they can present live. So you have to just have an understanding of what the internal resources will be, who you will need in order to succeed on that injunctive relief, as well as the cost and the commitment of the business leaders, because it won't just be them testifying at the injunction hearing. If the case goes on past then, they'll be deposed. The lawyers will need their help in coming up with defenses or prosecution arguments, depending on what side you're on. Obviously, use of external resources always needs to be considered. How much will it cost to do these forensics? Is the bang worth the buck? Also, do you want to get your customers involved? If you're going in on a non-solicitation argument, a lot of times it's good, from a legal standpoint, to have a customer say, yeah, Joe reached out to me, solicited me, and said that he could offer me, 10% off everything, and so I'm going to jump with him. But obviously, on business, a lot of times for business reasons, you do not want to get your customers involved. So those are some of the things to consider when we're deciding on injunctive relief. And again, that could be its own separate topic. So let me just hit the highlights there. And I'll leave you with two things. One is, and I think this has come out sort of as a theme throughout this presentation, be proactive. An ounce of prevention is always worth a pound of cure. Ben Franklin had it right. It's much better to address these potential issues and have a plan in place and have your agreements be enforceable from the get-go than have somebody leave, go into court, have a court throw out your agreement, or somebody leaves, takes your stuff, and you're scrambling to get things done and to get things to your attorney so that they can get into court to get your stuff back. So again, Uncle Ben had it right. Be proactive here. And so with that, I'll stop for any questions and to say thank you. Once again, this is my email address and my phone number. Feel free to reach out to me, and I'm happy to answer any questions you have.